Well, good morning, good afternoon, wherever you are in the world. On behalf of Level Access, welcome to our July webinar, the 2026 Legal Briefing. It's a mid-year trends in ADA litigation and EAA enforcement, focused on the Americans with Disabilities Act and the European Accessibility Act. We want you to feel empowered about the legal developments when speaking with your legal teams and when you're asked by anyone about the risk profile of your organization. So before we dig in, just some quick housekeeping items. Everyone is muted upon entry so we can keep things clear. Captions, there's real-time captions available down below in your Zoom window. And we've got live chat closed, but we would love to get your questions in the Q&A feature here in Zoom, and we'll be answering those as best we can throughout, as well as at the end of the session. And of course, don't worry, the recording is going to be shared with you and with everyone who's registered once it is captioned in the next couple of days. So let's dive in. Here we have a glowing 3D line graph resembling mountains. There's a flag at the highest summit, and lots of waypoints along the way. But if you're leading or supporting accessibility efforts within the organization, you probably get asked one question a lot. It's the same question that kids have been asking their parents for generations. Are we there yet? And just like kids on that road trip, legal, marketing, and product teams haven't really gotten a clear answer. And it's ultimately not the most helpful question. If you're leading or supporting these efforts, then what you're really trying to answer is, are we compliant yet? The word compliant really implies a finish line. Courts and regulators are ultimately trying to establish something different, though. It's not just about compliance. It's about whether people with disabilities can actually use what you've built and whether it's going to be something that you can show sustained good faith effort. So while we don't really want to say it's the wrong question, try telling an executive that they've asked the wrong question. Mm-hmm. But ultimately, what we want to be thinking about is, how can we answer this question when it's really not the right question to be asking yet? And since the Americans with Disabilities Act talks about effective communication, then I guess the question that we could be asking is, are we effectively communicating? And to me, as a blind person, effective communication means that I can take the same action, accomplish the same results with the same amount of effort in the same amount of time as someone without a disability. The only difference is I'm using assistive technology, as are people with all kinds of disabilities. It's a little bit of a lawyer answer in that it's got, 5 parts to a definition, but suffice it to say, is the experience you've built equitable? And so to kick us off today, I'd like to open a poll here on Zoom, and I would love for you to please just take a quick moment and answer this poll. And the question that we're asking you is about your level of confidence in the digital experiences that you've built. So how confident are you that you know the level of legal conformance or regulatory risk with your digital experience? So we've got very confident, somewhat not confident. We don't even get asked this question. So as you're thinking about that, I'll tell you, we asked the same question in our 7th annual State of Digital Accessibility report. How confident are you that you know your level of legal or regulatory risk? Overall, most organizations say that they're somewhat confident in their level of digital accessibility, 90+%. Now, if we ask that question about more broadly, all of your digital experiences, we still get, 4 out of 10 folks saying they agree. But let's take a look at how folks agreed here. And I've got our Chief Accessibility Officer, John Avila, to look through those results with us.
Great. Thank you, Corb. So 32% of respondents today on this webinar said they are very confident that they know their current level of risk or legal support for accessibility. So it's about just about a third. And then we have 56% saying that they are somewhat confident, and that's just over half of respondents. And then 8% are saying not at all confident. And then we just have 3% that are saying we don't get asked that question.
When we asked this question in our State of Digital Accessibility report, I think it's interesting, John, that 6 in 10 believe that they could still face legal or regulatory action in the year ahead. So they're really confident on the one hand of their digital experiences, of their primary one, and just as confident really in all of their digital experiences, but they're concerned. So the confidence isn't really translating into a legal or regulatory protection, which is an important disconnect and probably one worth paying attention to. The goal of our session today is really to focus on the legal and regulatory picture so you can better understand your real risk. You can focus the work that you're doing and focus that work where it matters most and answer that "are we there yet" question with the question you really hope they had asked. So let me introduce our panel today. So I'm Corb O'Connor. My pronouns are he, him. I'm a director of thought leadership at Level Access. I've been working professionally in the field of digital accessibility for about 15 years, maybe much longer than that if we count the years as a user of assistive technology. Built websites back in the 90s, built content, served as the program leader, and as somebody who has been focusing on consulting with legal and marketing and product teams since then. I'll pass it to you, John.
Everyone, John Avila, Chief Accessibility Officer at Level Access. Been with the company for over 25 years. One of my roles is to be a thought leader, be involved with the disability and accessibility community and industry. One of my roles is a member of the W3C, working on the web content accessibility guidelines. And then more practically, a lot of what we do is help organizations operationalize accessibility. Accessibility is more than just a technical standard. It's also a culture. In order to be truly compliant, it's an ongoing effort. So I assist organizations with that. Next, I'll pass it over to Eve.
And I'm Eve Hill. I'm a disability rights attorney and also a consultant. So I enforce the legal rights of people with disabilities, including in the digital access space. And I help companies, government entities, and employers implement their accessibility programs, particularly setting priorities, adopting policies, and so forth, so that they can achieve compliance. And I've been doing this for some 30 years in various different roles in government, outside of government, in local government, nonprofit, and now in a private law firm. I'll pass it back to Cord.
Thanks, Eve. So let's take a look at our agenda for today. We're going to, of course, talk about the Americans with Disabilities Act in 2026. There's updates to Title II, governing state and local governments, but there's also updates to Title III. That's the litigation side that we often hear about with private businesses. We're going to talk about the European Accessibility Act 1 year in. It took effect end of June last year, and so we'll give you a sense of where things are there. And then, of course, talk about the path forward, navigating your organization's risk, and followed by some key takeaways, and then, of course, your questions. And we welcome those questions all throughout. Just drop those into the Q&A box here in Zoom. Eve, pass it over to you to talk through the ADA in 2026.
Oh, there's nothing going on here. The ADA, it's all completely resolved. So the Department of Justice in 2024 released a new regulation specifically addressing the accessibility of websites and mobile apps under the existing equally effective communication obligation of the ADA Title II. In April of this year, 4 days before those regs were intended to go into effect, they delayed the regs using an interim final rule mechanism and delayed the regulatory start dates by a year. So now larger entities with 50,000 or more constituents have until April of 2027, and smaller entities have until April of 2028. That is the case. And Section 504 regulations by the Department of Health and Human Services the next month were extended by a year as well. So now larger entities, those with 15 or more employees, have until May of 2027, and smaller entities have until May of 2028. So they've at least done them in a coordinated way to extend those deadlines. That does not mean you should go, oh, we don't have to worry about this anymore. You clearly do have to worry about it, and you just have arguably, and I'll tell you why that's only arguably, a year more to get your program together and to make sure that you've addressed any substantive barriers that remain for people with disabilities to access your websites and mobile apps. The things that haven't changed are that Title II still applies. So Title II of the ADA still applies to all governments of all sizes. There's no delayed compliance date anymore for smaller entities. They're all covered now. And they are all required to ensure that their communications with people with disabilities are equally effective to their communications with people without disabilities. What does that mean? Well, now that the new reg, the web reg, has been delayed by a year, that means private plaintiffs' lawyers and defense lawyers can continue to argue over whether WCAG 2.0 or WCAG 2.1 should apply. The new regulation said WCAG 2.1, but some entities are still complying with WCAG 2.0, even though WCAG 2.1 has been around since 2018 and is really the more current and accepted standard. So that's leading to more attorney's fees, quite honestly. The obligation still exists. You can nibble at it around the edges, but the obligation still exists to provide equally effective communication, and that can still be sued over. Title II entities are still capable of being sued just for violating the equally effective communication standard. And the other thing that this means is there were 5 exceptions in the new web rule. Those exceptions, since they have also been delayed, do not apply to the equally effective communication obligation. So there is no out for making your existing PDFs accessible under the current standard. So there's a little bit of a drawback to that extension on the deadline. Nor have state laws that have parallel requirements been extended in any way. So California and New York and Florida and Illinois and Minnesota and others with their own state laws, those still are in effect. And then customers are still insisting on accessibility. So B2B and B2G vendors are still going to need to be able to address accessibility and ensure that the products and services that they deliver are fully accessible and meet the standard. So let's talk a little bit about enforcement. The ADA Title II is not in the news as much as the ADA Title III in terms of digital access. However, we all have heard of the Los Angeles Community College District case. We may have heard of the Oregon State University case. We may have heard of the West Virginia University case. There are cases proceeding through the court systems challenging Title II entities' failure to ensure equally effective communication. As I mentioned, the new exceptions in the regulation are not in effect because they were delayed along with the regulation. And that regulation delay may not survive. So this is another reason why you can't put off your compliance program just because the deadline has been extended. The Department of Justice and HHS, in extending the deadline, used what's called an interim final rule mechanism, which is designated for emergency situations. And so the National Federation of the Blind in May, shortly after the extensions took effect, filed suit in court challenging that interim final rule mechanism and the delay under the Administrative Procedure Act. So this courts could vacate those interim final rules and put the web reg and mobile app reg back into effect at any time that could happen. So there's still risk. Not only that, but presumably private entity advocates in particular have been expecting accessibility for their government entities and are not willing to put up with a delay. So since they can still sue, it's entirely possible that they will still sue under the equally effective communication obligation, even though the new regulation is not into effect. And there's a good argument that the DOJ, when they released that regulation, was doing exactly what Congress intended. Congress always said the ADA should keep up with technology developments, doing what advocates were seeking, and quite honestly, what cities and counties had said they were seeking. So it's looking a little disingenuous to argue that, well, we don't know what we're supposed to do when we asked you to tell us what you're supposed to do, what we were supposed to do. You did so, and then we argued, well, we don't want to do it. The bottom line is not a time to stop, not a time to slow down. Use any additional time you have to build a real accessibility program that makes sure that people trying to use your websites and mobile apps can do so with the standard that Core quite honestly laid out, with in the same time, with the same level of effort to get the same interactions and the same goods and services. Now let's talk about Title III. Title III is public accommodations. Most private businesses fall under Title III. And Title III does not have a new reg. So there's no regulation out there saying specifically what the standard is that Title III entities have to comply with, but they also have an effective communication obligation. So they have to ensure that their communications, including their digital communications, are accessible for people with disabilities. And there has been a good deal of litigation, private litigation in federal and state court over the inaccessibility of public accommodations, websites, and mobile apps. Say for that 3,117 federal web accessibility lawsuits were filed under Title III in 2025. That was up 27% from 2024. Those are only federal web accessibility lawsuits. Another company reports that they expect 6,000 digital access suits to be filed this year if you include state lawsuits. And more cases are now being brought in state court, particularly in states that allow damages under their local laws. So web accessibility cases now make up 36% of all federal ADA Title III filings. That's a big chunk. Again, that's up since 2020. And it looks like we may in 2026 exceed all of those. So what's driving it? It's getting easier to write a lawsuit. AI, artificial intelligence is helping with that. And people may have been holding back in 2025, waiting for the regulations to come into effect under Title II, and are now working their way through the system. The map is shifting a little bit. It used to be California was the #1 state where cases were filed because the UNRRA Act provides for statutory damages. Right now, California federal case filings are lower, but state level case filings under the UNRRA Act remain very high. New York is leading in federal cases filed in 2020, but they are also moving more and more into state court as judges in the federal court starting to demand more of plaintiffs in terms of standing, which means demonstrating that you would come back to this website if it were accessible. Florida is also another big area, second in the country, with 961 federal cases, nearly double what happened in 2024. And new hotspots are emerging like Illinois and Minnesota and Missouri, believe it or not. So there is no immunity. It doesn't matter that your business is not in New York or Florida or California, because your website is in New York, California, and Florida. And so people in that area can sue based on inaccessibility of your website, because that means the activities that are creating the legal violation are happening in that state and every other state. So you're not immune just because you're located not in one of the hotspots. Now, as I mentioned, there's a lot of state level work in the litigation front on Title III because there are very strong state laws that go even beyond the ADA. The New York human rights laws, for example, New York City and New York State human rights laws both allow for damages. The California UNRRA Act also allows for damages, including state damages, statutory damages that you don't have to prove. You automatically get an amount of damages. And then other states also provide for damages that you do have to prove. You don't get a statutory amount, but you do get to prove emotional distress, inconvenience, extra money that you had to spend. Any of those things can be compensable, as well as attorney's fees, meaning both the attorney's fees that companies pay their own lawyers and the attorney's fees that they'll have to pay the plaintiff's lawyers if the plaintiff's lawyers win. Now, some states are trying to curb lots of litigation. Missouri is introducing a cure law, which would give a covered entity a period of time to correct a barrier once it was identified by a client. And if the client, if they have corrected it in the time period, then the client would have no cause of action. Those are really aimed at the boilerplate lawsuits. They're not going to help relieve organizations when the person actually can't access the website. So it's very important to make sure that users with disabilities can accomplish the same things that users without disabilities can accomplish on your website, or you can get in trouble with that even in states with a cure law. So I want to talk a little bit about what courts actually care about in the Title III cases that we've seen. It's effective communication. They're not running a checklist or an automated test of whether you comply with WCAG 2.1. They're trying to figure out, is the barrier actually inhibiting a person from being able to use the website? So if a barrier is so minor that it really doesn't impact whether information is being communicated effectively, courts may not find liability for that. They're also looking at mootness. Have you mooted out the case by fixing the issues that have come to your attention and remediating all the barriers, and you're done now? So there's nothing further that they can order. You've already taken care of all the issues that you've identified. The other thing they'll look at is, are you preventing new errors from creeping into your website? Do you have a process in place to prevent the barriers from coming back? And then you can always make your defenses of undue burden, meaning essentially that you are going as quickly as possible to address the issues and cannot do it any faster or any better than you are already doing it. Or maybe, we haven't seen this work so far, you could argue that your vendor of certain pieces of your website or certain add-ons to your website refuses to remediate it. That might be an undue burden as well. And then fundamental alteration, I can't say you should rely on fundamental alteration. That only applies when addressing the barrier would fundamentally alter the experience of your website, and doesn't happen anymore. We are technologically capable of ensuring accessibility without undermining anything about our websites. So now I'm going to turn it over to John for the EAA.
Great. Thank you, Eve. Very informative. So right now, the European Accessibility Act has been enforced since June of last year. So it's been a full year, and so it's sort of this is like a milestone to reflect back and sort of where we were, what's changed, and what's coming, and what to expect in the future. So now the requirements aren't just theoretical; they have really moved into the here and now. And companies are starting to realize that compliance wasn't just the beginning; it was actually an ongoing effort that is important to maintain over time, just like privacy or security or user experience as well. One of the shifts that we're starting to see with enforcement is that the monitoring and surveillance authorities are doing more. They're investing in hiring people. They're starting to work together across the EU to share information. They're starting to use automation at scale to prioritize and detect accessibility issues in the market. So they're starting to look at high priority things. In the past, we've seen the EU market start to enforce areas like transportation and banking, so whether it be air or rail or sea. And they're also starting to react to consumer complaints, at the same time being more proactive in starting to find issues and start to proactively work with organizations to address any deficiencies. Ultimately, the point of the European Accessibility Act enforcement is to ensure that people with disabilities have equal access to consumer products and services across the EU. I would highlight, just like Eve said with the ADA, maybe it doesn't matter where your business is with the EU. If you have consumers in the EU, regardless if your company is based in the UK or the US or somewhere else, if you have consumers in the EU, then the EAA likely applies to you. So I guess to sum it up, we have seen enforcement is starting to mature. We're starting to see the market authorities measure and work with organizations to educate them. I would also just take this moment to highlight, even though we're talking about the enforcement of the EA, Europe has long had a public sector requirement for accessibility, both in procurement and the Web Accessibility Directive, which required websites and mobile apps of public entities to be accessible. Many times when you're dealing with things such as transportation, there's an overlap where organizations may have obligations both with the EAA and potentially under other EU laws. I mentioned earlier, compliance is sort of an ongoing thing. I would say that the EAA, we are not at the finish line because there is no finish line, but at the same time, compliance is an ongoing effort, but it's not a marathon. Accessibility is an ongoing process. I would highlight a few key points in here. Accessibility isn't just about the technical requirements, it's also about implementing those things into an organization. While it's an ongoing effort, it has to be sustainable and it has to be done in a way that allows the organization to implement accessibility, meet the needs of people with disabilities, but also be able to competitively work within the market. It's this continual effort. I think that is critical. Moving into the machinery of enforcement of the EAA, because each country had to create its own transposition of the law. Each country has its own market surveillance authority or authorities. Some countries have multiple authorities depending on the sector of business. And then each country has their own process, including penalties, enforcement procedures, et cetera. So what we have seen is the process has been a bit uneven across different countries, but there's a few countries that we'd like to call out specifically here. For example, in France, the four major grocery retailers, including Carrefour and Picard, to name two of them, were filed notices by disability advocacy groups. Carrefour was issued an injunction and given 6 months to fix the accessibility issues on their website. And if they don't reach that mark, they can get daily fines after that. They didn't dispute that they had accessibility issues. And so this is certainly a good opportunity to show that whether it be in the legal system or through market authorities, that advocates and people with disabilities won't hesitate to exercise their rights to equal access. In Germany, as soon as the law took effect, the BFSG took effect, we started seeing letters being filed by law firms, private law firms, basically saying that it was non-compliance for anti-competitive laws in Germany. So if a company wasn't accessible, then they weren't competing fairly in business, because part of the EAA is not just a consumer protection law, but it's also a law about fair business practices across the EU market. And so we're seeing those letters issued in Germany. More to come on the outcome of those letters, but we have certainly seen action. Moving on to two other countries as well, Sweden and Ireland are another one. So we've seen Sweden basically taking up the first accessibility cases, reviewing the common pages on e-commerce sites like the homepage, product page, search, and there are have reported over 120 some public complaints around accessibility. So they're starting to collect that documentation, prioritize those experiences, et cetera. In Ireland, we're starting to see surveillance efforts as well, with notifications being issued for more information, administrative cases being opened. So we're starting to see the market authorities are getting complaints. They're looking into those, asking questions. So they might be asking for documentation or proof that people are meeting these requirements. And then in the Netherlands, one of the things that we're starting to see is more of this mandatory reporting of non-conformance and more enforcement coming. So they're doing a lot of automated testing and testing to look at the accessibility of different sites. But there's several countries are now saying it's not just enough to put on your accessibility statement that you are non-conforming. You actually need to submit a form to us on our website telling us that you're non-conformant if you're non-conformant. And so that step is very different, and it is country by country basis, where you may have to report or you may not have to report non-conformance. We have seen many people simply putting that information on their accessibility statement, but definitely check the countries that you are operating in, that you have consumers in, to make sure that you're following those country-specific requirements. And then just a real quick mention as well on this slide that, there's B2B2C companies, so have business to business, but then consumers use their products. So just mention that it's not just B2C companies that are impacted by the European Accessibility Act. If you are a company and your product is sold to another company, but they turn around and use it with consumers, then you may have some implication for accessibility, whether it be a business need of your customers, your business customers, or maybe there is even some shared responsibility with you and your business customers when end consumers use the product. So it's just something to keep in mind. Looking at the penalty landscape, we don't have any confirmed monetary fines at this point, but I would highlight that the fines range either like tens of thousands of euros to hundreds of thousands, or even close to €1,000,000. For example, with Germany with 100,000 per violation, with up to €1,000,000. Netherlands close to that 900,000 or 10% of the annual turnover, or with Ireland at 60,000 per violation. So those are very, potentially there. What we are finding as well is there's always the threat that you could not be able to do business in that country. You could not be able to sell your products or services in a particular country or in the EU as a whole. So while we haven't seen these come yet, they could certainly happen. And so it is something to think about. And then to follow up on my last comment, from a business perspective, if you're a B2B2C company, we are seeing more companies be strict in their procurement processes. So if you sell to other businesses, those businesses are likely asking for conformance documentation and proof of accessibility. So we are seeing organizations really start to have to address accessibility to sell into that B2B2C market. So just keep that in mind as well. And then, so what to expect in the future? So we are seeing more monitoring, more scaling up of those processes. There will be a new version of the standard of conformity, which is EN 301549. We are expecting that to be published in the second half of this year. So in the next few months, that will be published in the official journal, and that version will become version 411. That will include WCAG 2.2 plus additional requirements. So that updated standard, when it's published, will essentially become sort of the presumptive standard of conformity for the law. And so that's really important to keep that in mind. That new standard is something that we're building into our products to support that. Emergency communication requirements will come into effect. We're seeing more accessibility requirements as part of other laws like ESG, environmental, social, and governance. We're seeing accessibility in some other laws around AI use, just like we saw accessibility as part of GDPR with privacy and data regulations in the EU. So we're just seeing accessibility as more and more part of these other laws that are being passed. And then lastly, I would just highlight, really, to be successful with accessibility, it's more than just a technical standard. So we would strongly recommend an organizational management standard to help ensure that your accessibility efforts are part of your organizational culture. And so that European standard, which I think will get a lot more attention, is EN 17161. That's a Design for All standard, which will help organizations implement accessibility across the organization. Okay, I will pass it over to Cord.
Thanks, John. So let's take a look now at the path forward and how you navigate your organization's risk. Compliance, as you've heard each of us say probably more than once today, compliance is not a one-time pass or fail exercise. It's about ongoing access and effort for real users. Too often teams we work with are chasing that clean accessibility conformance report or voluntary product accessibility template. They want their VPAT to say pass all the way down. And the interesting thing that you can note about an accessibility conformance report is if it has passes all the way down with no comments, it tends to raise more questions than it does create certainty for the reader. And it's not because we don't want to see that, but it's that not every criteria is going to apply in every situation. And so if your app, doesn't have any audio or video, but you tell me that it passes the requirements because all video has transcripts, I start to wonder how much you really paid attention to completing that report. If you don't have any notes about where users might get stuck and what the workarounds could be, or what some of the friction points are that are accessible, but maybe will trip up a user, and maybe there are points at which this app can be used in a way that isn't yet fully accessible. Those are the kind of things that a procurement organization really wants to see. Here we have an image of a smiling young man with looking at a tablet with a rising line graph behind him. I think we would all be smiling if we saw that our line graph for digital accessibility was increasing. We want to make sure that it stays above a level of conformance, but we also want to make sure that it's meeting the needs of real users. So how do you meet those needs in a global marketplace? The good news is that all of these standards, whether it's the European Accessibility Act, the Americans with Disabilities Act, Section 508, the Accessibility for Ontarians with Disabilities Act, they all have their basis in the Web Content Accessibility Guidelines. Now, there are some nuances, so you need to be aware that the European Accessibility Act has requirements, as one example, for point-of-sale devices and specific things about headphone jacks and what should happen when users enter their PIN and all of those kinds of things. But the fact remains that testing against these standards really isn't a laborious exercise for most organizations, because you're going to be looking at the same Web Content Accessibility Guidelines with some extra nuances in different places. The second, as John just mentioned, is that we want to see organizations implementing program management processes. This 17161 standard from Europe really gives us that non-technical standard. It's voluntary, but it helps us bring accessibility into everyday work. It gives teams a simple, repeatable framework instead of technical rules. Those technical rules are important, to be clear, for designers and developers and document producers. But this helps you to look across the organization to look at the level of maturity. So we want, with that framework then that you're working through, it encourages organizations to plan for accessibility from the start and to watch that trend over time. It helps leaders set clear ownership so that accessibility isn't left to one person, or maybe worse, to chance. It really helps to scale from one project to a consistent organizational, repeatable practice. And it keeps teams doing accessibility early, regularly, and intentionally. And it really pairs well with the Web Content Accessibility Guidelines. And the third thing that you can do across markets is stay connected with users with disabilities. You can test with trusted partners and with real users. Lots of folks will say, oh, we're fully conformant. The solution we're providing to you, yes, of course it's accessible. How could it not be? And yet we know more than 95% of the web is not accessible today. But we also want you to be evaluating your support channels. So often a user with a disability isn't looking to sue you for a quick buck. They actually want to give you a quick buck because they want to buy your product or service. And so when it comes to that level of evaluation of your support channels, think about, okay, if I'm a user and I'm struggling at this point, how can I get in touch with support? Is it really straightforward where there's a phone number to call, there's an email address on the website? If I fill out that contact us form, is there a CAPTCHA that might trip me up if I'm a keyboard user or a low vision user? Have I made it really straightforward? Or have I stuck the user in the internet's version of the voicemail tree, where all they want to do is scream to get a human, and yet they have to go through this series of menus that so often lead you to a page and say, was this page helpful? No. And then only to find, thanks for your feedback. Well, I still have a question, but no way to get in touch with you. So what can we ask instead of are we there yet? Can we show documented evidence that we are moving as quickly as possible and dedicating as much as we can to improving digital accessibility? That's what one of our customers found success with earlier this year in New York State when Mosca, the online retailer, was able to demonstrate through reporting from Level Access that they actually made meaningful progress with digital accessibility. They were prioritizing the issues that block real users and caused problems for users. Maybe even looking at things like an error state of a form. If I don't complete the form in its entirety, it's probably not because I didn't want to complete it, but it's because I had trouble. I either didn't understand what was needed, I didn't see that form field, I didn't know what format the data was wanted in, the date picker was the problem. And so making sure that we're evaluating those error states as well. And when we're able, like Moscot, to demonstrate meaningful progress to a court, we're able to then say that this is ultimately meeting the needs of real users with disabilities. We've seen financial services organizations focused more on their hundreds of PDFs than the application and information for a loan or a checking account. And what happens then is we're chasing legal conformance for something like documents, but we're missing the big picture here, which is that users with disabilities need checking accounts just as much as anyone else. And then think about those baseline requirements. Do we have things like an accessibility statement that says how we're working on accessibility, where users can submit feedback, what those channels are? And as I mentioned, it's going to be difficult to be able to contact you if that CAPTCHA on the contact form is the problem. So we really want to shift the conversation of are we there yet away from a yes, no, and toward defensible compliance, thinking about whether we have the fundamental components of an accessibility program in place, roles, responsibilities, training, progress for our team. So let's go back to Eve now to walk us through our key takeaways from today.
Key takeaways. Well, the little plateau in filing lawsuits under the ADA Title III is over. Title III filings are rebounding, and European enforcement is working through. So those things are happening. The extension has happened. Not sure it will stand because it's being challenged, but the underlying obligations are still there under both the ADA and state laws. So we can't sit on our hands and wait for the extension to roll itself out. And then I think the key that Corb discussed was you got to focus on users. The requirement under the law in the US is effective communication. It's not a measuring stick or a checklist. Courts and regulators care about whether users can actually use your products, can actually access the information that you're putting out there for them, more than they do a VPAT score. And even now, especially now, even if you're not a lawyer, you can use your insights on the compliance landscape to strengthen your business case for accessibility within your organization. You, no matter who you are, can be a champion for change in this current landscape where being a champion is really, really important and will save your company money, time, energy, and customers.
Thank you, Eve.
Now I'll turn it back.
So from Level Access has been helping organizations for over 25 years create and build accessible digital experiences. And there's 4 points I would like to highlight how we assist organizations by understanding the obligations, the regulations, the standards, what's different in EN 301549 from WCAG, how do you implement an organizational standard within your organization. Also, point number 2, evaluating your risk and your user experience. Risk isn't just meeting the technical requirements, but it's also going back to the user. Can users with disabilities, perhaps using assistive technology, can they complete the core flows, the core tasks? As Corb mentioned, will they get hung up on an error message? Understanding how real people use your services and products and whether they can actually purchase your products and services. Understanding that is key. And our team of experts and people with disabilities who use technology can assist with that. Point number 3 is validation of any demand letters or any complaints. So many times there are demands that are unclear or generic, and sorting out all of those things that are best practice from things that are actually preventing the user from using your site can be tricky. And we can support that from a technical standpoint to understand whether it is an issue or isn't with assistive technology or on a mobile browser or on your desktop. And then the fourth point is to build an evidence-based accessibility program. And this is really key because almost every time when we look at a settlement agreement, it always covers certain things. Do you have the processes in place? Do you have a person who's in charge, that champion or leader? Do you have a policy? Do you have the right tools? Are you working with a third party? Basically, have you done your homework? Are you preventing accessibility issues from being introduced so you don't get stuck in that break fix cycle? And if you can show and you have a defensible program in place, you're doing as much as you can to address accessibility, then you really create a strong process that is defensible, but also means that the outcomes are successful and is sustainable for the long term. I'll pass it back over to Corb to jump in to lead our Q&A session. Hopefully we have some great questions coming in. Corb, take it away.
Yeah, would love to get your questions answered. So drop those into the Q&A box in the bottom of the Zoom window. First one, we get asked this a lot, John, for you on the European Accessibility Act. If a company is purely a business-to-business company, maybe even like a software company, they face penalties under the European Accessibility Act?
So that's a great question. I'll give a technical answer because I'm a technical person and not a legal expert. So we find that sometimes there can be a shared responsibility with a B2B2C company, especially if something is branded in your company and consumers are using that product and it appears like it's coming from you. So in those situations where a company is buying your product, but then uses it with consumers and it appears to be coming from you, there might be some shared responsibility. Again, I would talk to your legal team on that. In other situations where it's more purely B2B and consumers aren't using it, or perhaps it's in some other way, then maybe that's a different situation where there's less risk and it's more of a business requirement where if you want to sell into that market, you need to be accessible. So it really depends on some of those factors.
Thanks, John. Question for you, Eve, is one about the recent consent decree regarding Pearson and the employees using screen reading software. And really, with so many organizations struggling just to get to 2.1 AA compliance, what, if any, a broader impact do you anticipate this might have on higher ed institutions and organizations?
Well, I think it informs us all that we can't rest on 2.1, which, as I mentioned, is already pretty old and has evolved into 2.2. That being said, the differences between 2.1 and 2.2 are not burdensome on an entity to comply with the most current WCAG standard. So I think that Pearson's clearly in a position to comply with WCAG 2.2. That is the standard that's out there. That's the standard the EEOC went with for this particular respondent. And I think more and more courts will be looking to 2.2 in the Title III space because it's been around long enough. We know how to do it, and it's not a tremendous lift to comply with 2.2 rather than 2.1.
And John, maybe for you, can you give us a quick sketch of the difference between 2.1, WCAG 2.1 and 2.2, and the just how 2.2 is, as I understand it, is just a little bit of a flavor of 2.1.
Yeah, so each version of the Web Content Accessibility Guidelines build on each other, and they're backwards compatible. So if you conform to 2.2, you're also conforming with 2.1, which makes it a lot easier. I would add the most common level of conformance is level A and AA. So in order to be AA, you're also level A conformant. Most regulations, most laws tend to cite that. And so at level A and AA, there's 6 additional criteria in WCAG 2.2. So it's basically 55 total criteria that would have to be met. So it's very incremental, as Eve was mentioning. And most of those requirements are best addressed during the design phase because they may impact things that would affect the design of a system. So I would just keep that in mind, that it's always good to be thinking about these requirements as you're designing and building things rather than treating them like an after the fact, because it may be a little bit more difficult to sort of fit them in after the fact, but it can certainly be done.
And Eve, when somebody hears from a user that, hey, I've reviewed your website and I found issues, and then they go in and say, well, the issues that you're identifying are actually not real accessibility issues, or they're not passing, they're from our standards, they definitely pass the web content accessibility guidelines. What would you suggest as a response when they get this kind of comment from users of their site?
I would engage with the person. What were they using? What access technology were they using? What browser were they using? What operating system were they using? And then try to replicate it with the same things, because that's often where the disconnect happens. Having done that, if you can't replicate the barrier, I think you give less weight to this level of feedback because you can't replicate the barrier.
And John, for you on Title II, and maybe Eve, you want to comment on this too. Does the Title II regulations, what impact do those have on private businesses?
They don't have any direct impact on private businesses, except the private businesses that are supplying state and local governments. They need to comply because their customers need to comply. And it's a really bad business strategy to get your customers sued. But it doesn't directly apply to Title III entities or business entities, but it certainly shows where the Justice Department is going and what's likely to be required of Title III entities.
I would mention that Hawaii recently passed a bill that would require a commission to create some standards around accessibility for the places of public accommodations. And they modeled it based on ADA Title II rulemaking with similar exceptions and similar requirements with WCAG 2.1 and AA. So while it may not directly apply to businesses, we are seeing states take that type of language that was in the rulemaking and starting to create requirements for places public accommodations under Title III.
And then maybe a last question for either of you. What does this documented evidence of compliance really look like? Are there a minimum set of artifacts or of documents that an organization should have?
John, you want to take that?
So yeah, that's a good question. There's certainly, it depends on the laws and regulations. Okay, so for example, in Europe, there may be an accessibility statement that's required that communicates the things you've done for accessibility, the accessibility of the product and services, what the service does, who to contact. So there's certainly some requirements depending on the region of what's in that statement. For example, on Ontario, you have to have a multi-year accessibility plan policy. The plan has to cover specific requirements. In France, under RGAA framework, you have similar requirements for a multi-year plan and statement and certain information that must be included in that. In the US, there may be a little bit less specific as what's required. For example, under ADA Title II, the standard is WCAG. It doesn't really go into the documentation and organizational maturity. That was something that the Department of Justice was looking into, because ultimately, I think future accessibility standards will start to go into what are the things an organization should be doing to demonstrate maturity, and what are these processes? And that's something that could be in future versions of WCAG, like WCAG 3. But I'd say I would typically look to what we see in demand letters and settlements and those types of things, especially what is the government asking organizations to do? And those are some good examples of things that you should be doing in your organization.
And under the ADA, it's up to you to prove your case. So you have to prove that a defense applies, or that something, or that you're doing all you can do, or that, so you need to document that as much as you can to make your defense. And I will note that the defenses of undue burden and fundamental alteration have to be documented at the time that you made the decision not to proceed with fixing the barrier. You don't get just to get later say, well, I'm being sued now, I'll say it's an undue burden now. You do have to document those things at the time.
Well, thank you, Eve, and thank you, John. We've got QR codes on screen for everyone's LinkedIn profiles. We encourage you to connect with us on LinkedIn. I'm on the left, John in the center, Eve on the right. And John, thank you for joining. Eve, thanks for being here with the great lived experience that you've had over those decades of fighting for the rights of people with disabilities. John, from a technical standard. And just know that we here at Level Access are eager to continue the conversation with everybody here. We're eager to provide both the ideas and advice about what to do to avoid litigation or to respond to litigation, but more importantly, to how to create a more inclusive experience for folks with disabilities, so that as you're going out and you're doing the work of finding and fixing accessibility issues on your website, that you're proving compliance, that you're learning along the way, and most importantly, that you're working on accessibility proactively. We're here to be your digital accessibility partner in that effort. Thanks for joining us for today's webinar on the 2026 legal briefing, a mid-year update on ADA litigation and EAA enforcement. On behalf of Level Access, we hope you the best day.